Good morning and welcome to Trial TV Live. I am the Squeegee of Justice with a little Super Ball, my paralegal coming in. How's everybody doing? Good to see you. Thank you for joining us as we continue our coverage of New Jersey versus Sean Higgins. And let me get you over here. So, for those that don't know, this incident happened at All right, hold on. Let me just do a switcheroo here. Just give me a moment, guys. What's today? Today is the 15th. All right, let's go and find this. There we go. Okay, got the right date now. All right, so for those that don't know or are not familiar with this, this happened last year, August 29th. Let's see, the Gaudreau brothers were in New Jersey for a wedding of their sister, and they were struck by Sean Higgins. He was driving, he had been drinking for several hours. I think he said he had about 6 or 7 beers. He was driving around talking to a friend, and he was drinking. And apparently he went off the. There was a car or truck in front of him, and he went on the other side. He tried to pass on the right side, so he passed on like the berm, if you will, or the sidewalk. I guess there really wasn't a sidewalk, but there was like like it was in the country, right? So there's like an area that's not the road. And the Gaudreau brothers were bicycling. They were on pedal bikes, and Sean Higgins hit them, right? And they're no longer with us. So he's being charged. Higgins is being charged with 2 counts of second-degree vehicular homicide, 2 counts of first-degree aggravated manslaughter, 4th degree of tampering with evidence because apparently he drove away a little bit. I think he went like about a quarter of a mile or so, but his car or truck, I think, he couldn't even drive it, right? That's how damaged it was. And then 2nd degree leaving the scene with a fatal accident. So I think the tampering with evidence, he was trying to hide the fact that he was drinking when police finally did arrive. So now Sean is also saying, well, because Matthew and Johnny were drinking because it was the night before their sister's wedding, of course they're out partying, right? They're having fun. So he's saying, well, because they were drinking, their blood alcohol level was higher than his, that he should be exonerated. So that's where his BAC was 0.087, and it's legal is 0.08. That's pretty much around the country is 0.08. The brothers, I forget what their level was. It was fairly high. It was definitely higher than maybe it was like 0.1. It was pretty high. So they were, what? So what? They were drunk and they were riding their bikes. Big deal. Not causing any harm to anybody. So. Hey, Ohio Jen. Yes, it is sad. Oh, wait, hold on. Let me pull this above. Give me a second. There you go. Joanne, how are you? MEG, good morning to you. Krista, limited edition. So good to see you. We miss you too. Always nice to see you in our chat. Therapist, thank you for joining us. Baka, hello to you. Ella Blue, good morning from Alberta, Canada. Fantastic. We have lots of Canadians with us and in our chat. Thank you for joining us and saying hello. Queen Olive Ruth Ann, good morning to you. Mac RN, good morning to you. Selena K, I'm sorry you didn't have a good night, but hopefully today will be better. Pammy, Pammy, how are you doing, Pammy? Let's see, who is first in chat? Who wins the internet today? Oh, OnlyFan. And Casey TC77. And Joe, Andy Joe. Awesome. Thank you for joining us, you guys. I can't pull those up because I can't scroll back that far, but that's okay. Fanny Pack, how are you? So Aaron sent me, so Johnny's BAC was 0.129, Matthews was 0.134, and Higgins was 0.087. So, hey, only fan, good to see you. You were first. Hola, hello to you. MG, good to see you. Thank you for joining us. Emmy, thank you so much for the $4.99 support. Appreciate that. Thank you so much for that. And I will reply here. Thank you. Very sweet of you. Thank you. Christine Aitken. Oh, there you are, Christine. Hello from, good afternoon from Scotland. Yes. Good morning, good evening, good afternoon, as Baker likes to say. I'm not going to steal his line. Hey, Hazel. Thank you for joining us. Appreciate it. Pammy also saying hello and thank you to everybody. Hello, Blue. I like your, are those pandas? Those look like little pandas. Nice. So that's kind of the backstory of where we stand right now. They've had a couple, and this is in Salem. It's being taken, or the court, the hearing is, trials taking place in Salem, which is down by Philadelphia. Let's see how far. Let me see. Just to give you guys some perspective, Salem, Pennsylvania. I'm sorry, Salem, New Jersey. Thank you. Salem, New Jersey is, so it's kind of across the Delaware water. I know, what is that? Delaware Bay. So you got Wilmington's just north and then west, and then Philadelphia is east, north and east. That's kind of where, not kind of, this is where this is taking place. So it is taking place in New Jersey, but it's very, very close to Philadelphia and Wilmington. I'm pretty familiar with that area. And it's fairly country where this happened. So rural, if you will, not like rural country, but it didn't happen in a city, right? So these guys are riding their bicycles and they get hit by Sean Higgins. So now let's see, okay, so the judge is Michael Savanio. That's our judge, Michael J. Savanio. I'm trying to find out if I know. Okay, the wives. So the wives, yeah, they celebrated their. Okay, so Johnny's wife Meredith celebrated their daughter's second birthday 1 month after. Let's see. So December 2024, Higgins was indicted by a grand jury, right? January of 2025, he pled not guilty, and he declined a 35-year plea deal. So he did decline a plea deal. February, he remains in custody as a flight risk. So that's where we stand right now. Okay, so that's where we are right now. So today is the 15th, tax day for those in the U.S. For those that participate in paying taxes. Today is tax day. Let's make sure we pay our taxes to our good old government so that we can continue to do what we do. All right. So we're hoping to find a feed. We're pretty confident. Aaron looked on the docket, and it is still on the docket. So it's not like on any major streaming service. So we actually have to go to New Jersey courts. Kind of like, I don't know if you guys remember, we did that Colorado. What was that? I forget the kid's name, where he killed like 15 people or whatever. It's kind of like that, where we have to just kind of refresh and hope that it pops up. So that's where we are. Hazel said Johnny just had their third baby, by the way. Yeah. She was pregnant at the time, right? She was pregnant at the time, and just absolutely, absolutely terrible. Thank you, Hazel. Yeah. Um, and the NHL did all kinds of tributes and honors, and no, I'm not going to play them. But yeah, Johnny, he played 11 seasons. He was with Calgary Flames. He was drafted. He was drafted in the fourth round, 104th overall in 2011. He played with Columbus, the Blue Jackets. That's where he was playing when he passed away, or when he got killed. He didn't pass. Well, he did pass away, but when Higgins decided to, and I think there's even not. I think there was some like road rage in this as well, because normally in the States you pass on the left, right? You drive on the right, you pass on the left. He passed on the right, where there was no lane. It was basically like side. I keep saying sidewalk. What's the right? It's a berm, I guess. It was like a berm. I guess bikes were able to ride. It was enough so bikes could ride. But okay, we have a feed. We got a feed. Hold on, guys. All right, Salem. All right. Give me a moment. Let me pull this up.
No close captioning.
I know, right? Okay, now let's see if I can get this large. Yeah, there's no closed captioning, you guys. So just so you know. All right, hold on a sec. All right. So that is them spinning. So we shall wait for court to begin. This is Judge Silvanio's courtroom. Just went away from me. It's all right, we just have to wait. It seems like they may have taken it away. As quickly as they gave it to us, they took it away. Hey, Katya, how are you today? Good to see you. Thank you for joining us. I hope you had a good birthday, and congratulations on 1,000 subscribers. Fantastic. Yes, Hazel, check out our description box, MG, if you're looking for more information. We try to make our description as good as possible, as detailed as possible. There's always stuff, obviously, that we miss, but you can definitely check the description. And thank you, Hazel, for saying that. Hard shoulder, yeah. I think it was more than, yeah. It was wide enough that he felt he could go around, right? So it wasn't like it was just the bike lane, because a lot of places, you'll just have a bike lane. Like you got your main lane for the cars, and you have a little bike lane that's like maybe, I don't know, 3 feet. It seemed like the shoulder was, but you're right. I think it is a shoulder. It was wide enough that he felt he could go around this car. I don't know why he did that, but that's what he did. Oh, come on, court. Don't do this to us. Oh, thank you, Krista. Appreciate your support. Thank you for covering this case. My brother knew him before he passed, and no one is covering it. Thank you, and I'm sorry, and thank you for saying that. And I know that you miss your brother terribly. So thank you, Krista. It's kind of bittersweet. Yeah, now that we have you guys here, let's hope that they show it because they've taken the feed away from us, of course. Ugh, I hate when they do this. All right, we're going to keep looking.
And this isn't being shown anywhere else, so we have to stay with this.
Yeah, I'm just doing that just in case. You never know.
But they're all getting it from here.
Yeah.
That's the whole thing. Like, Crime showed it months ago, and it was from here.
Right. Yeah. Well, that's the thing when if they do show something, if another channel shows it, they just get it from here, and then it's only the one source. So
yeah, like crime is not in this court.
no.
Nor court TV.
Columbus Dispatch, because Johnny played with the Columbus Blue Jackets. They do news on it, but they're not. They don't have it on there. Everybody pulls it from here. It stinks. I know. We had it for a minute there, you guys. This is the pain that we go through as content creators, trying to show you guys something that we're interested in, and it's all dependent on the court. We'll stay here. We'll stay here until we'll stay here for a while. Maybe it'll kick in. Maybe it won't. Who knows?
I mean, it literally was there.
Mm-hmm. They had it. Now it's gone. They giveth and they taketh away. Hey, Joni, good to see you. Thank you for joining us. Let's see. I can say hello to everybody that's coming in. Hazel says both of their wives were pregnant and it was the night before their sister's wedding. MG says, oh no, this hits home for me. One of them is Matthew. Oh no, that was my twin's name that passed away in 2010. Yeah, Krista, it's no one's covering it. It stinks. I don't know why people are not covering it. I mean, they're doing like little maybe news. Oh, nope.
Wait, Salem. Nope.
I don't know why this doesn't have. It's not more prominent. To be quite honest, I don't get it either.
Yeah, I have no idea.
It's a shame. It should be. Yes. Happy birthday, Katya Mbaka. Hey, Angelique. Good morning to you. Hazel, we'll stay on it as long as we can. You know, I mean, we can only do so much. We're not in the courtroom. We don't have a courtroom insider. We can only go with what they give us. So right now it's Bupkis. Hey, Shore Life. Hello to you. Thank you for joining us. Good to see you. Shore Life goes way back with the channel. All right. So we're waiting for the feed to kick in, you guys. It's a Zoom feed, so we can only do so much other than just sit here and wait and refresh the page. So hopefully they will kick in soon. We had the feed, as you can see, but they cut it, so now it's just spinning. But it'd be interesting if it kicks back in. If it'll be the same feed or a different one. We'll have to see. Oh, Joanne, thank you for gifting one Trial TV Live membership to American Girl. Fantastic. Come on down, American Girl. And Joanne Jedi Platypus gifted you the membership. Hola, hello, how are you? How are you doing today? I hope you're doing fabulous today. Fabulous Fala. Katya, wow, 3 months, much longer, but love it here. Yes. Katya, you have been around since like November, October, maybe Sarah Boonish around then. Hey, Dave, how are you? Thank you for joining us. So for those that are just joining us, we are waiting for the feed to kick in. It's a Zoom feed. We had it for a second, and they took it away from us. So this is coming out of Salem, New Jersey, and we're waiting for the court to give us their Zoom feed. And like I said, we had it for a minute. You can see the spinning wheel, but they took it away. So. And if you have any questions about what we're watching and why we're watching it, it's in our description. So Sean Higgins, here I can go back to this for a moment. Sean Higgins was driving around drinking, and the Gaudreau brothers were in town for their sister's wedding. They're both very well-known hockey players. Johnny a little bit more so than Matthew. Johnny had a little longer career, a little bit more storied career, but they both, in their own rights, were very good hockey players. They were in town for their sister's wedding, and they were drinking, partying, but they were riding bicycles. And Sean Higgins was drinking, driving around in his truck, and he went over on the shoulder trying to pass another car, and he struck and killed both Johnny and Matthew. He was charged. He left the scene. His car was so damaged. His truck was so damaged he could only drive it about a quarter of a mile or so. And then when the cops got there, he was like, "Oh, who, me? No, I wasn't doing anything." So he was trying to tamper with evidence as well. So, and this happened August of 2024. So we're trying to bring you this trial. Well, actually, it's not the trial yet. It's just it's a pre-trial, some motions. Trying to bring it to you, and we're waiting for the feed to kick in. And we had it for a moment. But yeah, still spinning here. Hey, Jen's just watching. This is in your neck of the woods. Thank you for trying to stream. There rarely anything covered live from. Yeah, it's a bummer, Jens. I wish that I wish we could. I wish they would give this to us. I don't understand. Hey, Curviel, this one's going to infuriate me too. Defense trying to put any blame on the brothers is just pathetic. Katya, the spinning wheel of unaliving. Right? Yeah, Curviel, to get back to your point, now Sean Higgins is saying because his blood alcohol level was 0.07 and the brothers was, Johnny's was 0.129 and Matthew's was 0.34. He's saying, oh, well, their blood alcohol was higher than mine. So, it's their fault. Yeah, that is pretty infuriating. I agree. But we shall cover it, such as it is. I'm still waiting for this Jersey court feed to kick in. We'll stay here for a little while. Yeah. They gave it to us for literally like 30 seconds, maybe a minute, and they took it away. Other feeds are working. Their other feeds are working. Hey, Brenda. Good morning to you. Thank you for joining us. Yeah, Angelique, they weren't driving a huge weapon. I hear you. Sure life, always the victim blaming is how they think they can get away with it. Agreed. Hey, Karen, Higgins did not know well, he didn't know him personally. He may have known their names if he's a hockey fan. He,
That they were driving.
no, but afterwards he may have found out. Yeah. Kerviel, yeah, I mean, if only they weren't drunk too, they could have swerved out of the way or seen him coming. As far as I know, they were hit from behind. I think they were hit because if you're riding a bike, you would ride with traffic, right? And he tried to pass on the right side onto the berm, onto the shoulder. I think. I don't know for sure, but I think he hit them from behind. I don't know that for sure. We'll have to find that out later. But his vehicle was so damaged that he could only drive it like a quarter of a mile. Hey, Angela, how are you? Good morning to you. Thank you for joining us. Are we covering Karen Reed? We are not. We are not going to cover Karen Reed after the ding bell. Sorry. Seeking Justice, good morning to you. Thank you for joining us. We're hoping to bring you a feed, but it's not looking good right now, you guys. This is coming from New Jersey Zoom, and we had it for a second. As you can see, the spinning wheel there, the spinning wheel of unaliving, as Katya says, which is a shame because this is something that needs to be talked about and covered, and I don't know why they're not showing it. And as soon as I stop the feed, they'll show up. So we're going to stick around for a little while. We'll stick around. Just in case we may get a brief moment of it. Let's see if there's anything else. 3 hours ago, Columbus Dispatch. Driver due back in Tuesday. So Michael Savanio will hear arguments from prosecutors and attorneys for Sean Higgins about several legal issues related to the charges and what evidence a jury would potentially be able to hear. So he was driving a Jeep. So attorneys for Higgins have requested Savanio throw out the indictment, or at least parts of it. In motions filed before the hearings, attorneys said prosecutors had not presented evidence to the grand jury about the blood alcohol levels of Johnny and Matthew. New Jersey does not have any law against bicycling while intoxicated. So there you go. You could be drunk as a skunk and be riding your bike, and everything's cool. Prosecutors have asked Savanio to keep any jury that might be asked to decide the case in the future from hearing about the brothers' toxicology reports or results. Prosecutors argue the brothers hadn't broken any law, and witnesses were clear about the brothers not riding their bicycles in a way that contributed to the crash. So there you go. They were just riding away, riding along, Attorneys will also present arguments about whether Higgins has received fair treatment by prosecutors. His attorneys have said in court filings that the celebrity status of Johnny Gaudreau has led to harsher, unfair treatment for Higgins, including an initial plea offer that included a proportionately high sentence. He rejected the plea in January that would have resulted in a 35-year prison sentence. So he kills two people, which is about 17 years each. He says that's too high. I know, right? So even within in that story, it said here you can watch live, and I clicked on that, which takes us to the same same page, and there's nothing. So, oh man, come on, yeah. Look at my text message. This is at the very end of the story. Yeah. 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 So, guys, we're waiting. Hopefully, this feed will kick in. Sure, but what happens if it kicks in? we're screwed. I mean, there is a possibility that they're running late. I get that. So I'm just reading another report here. It seems like what they're going to be really talking about is the blood alcohol levels. So let's see. Action 6 News. Let's see if Action 6 News has anything. Action 6 News. Philadelphia. Doesn't look like Action 6 News is doing anything. So for those that are joining us, we are just waiting for a feed to kick in. They were supposed to start at 9. Hopefully they're just running behind. This is the Sean Higgins, New Jersey versus Sean Higgins for driving. He was driving around. He had gotten off work. He was driving around for many, many hours. I think he had consumed about 6 or 7 beers. He passed on the shoulder side, and he struck and killed Matthew and Johnny Gaudreau. They, as you can see, were pretty well-known hockey players. They were in town for their sister's wedding, and they are no longer with us. And this happened in August 2024. And We had a feed for a hot minute, and then they took it away from us. So we're just sort of waiting. Hey, Runs with Scissors. Thank you for joining us. Appreciate it. Let me see. All right, I can show the body cam. Let me show this at least. I may have to cut into this in case they do come live, but here's the body cam. We can at least watch this. Yeah. No, let me grab it though. All right, so here's the body cam. We'll show this while we wait.
All right, where were you coming from, sir?
Taco Bell in Pennsville.
Here's your ID. Where were you before Taco Bell?
My house.
Okay, how much have you had to drink today?
I mean, I've been drinking beers, but I haven't had one in like 2 hours.
Okay.
So since the accident, like probably an hour or so.
Okay.
Yeah.
I'm gonna run you through a few tests.
Yeah, that's
All
fine.
right, go ahead and put that cigarette out.
Yeah. And just FYI, I had surgery on my knee on Friday, so
Okay.
I'm gipping around.
All right, we'll get there.
Man.
Kill the lights in front of your car real quick.
Sure.
Step over here for me.
Yep.
Give me your phone. Just back right up to his car.
Yep.
The lights for me. Yeah. Excuse me.
Yep.
Alright, what I want you to do, just so you're kind of more my height, is lean back into that bumper, kind of sit on it. Lower, right there. Alright. See the tip of my pen?
Yep.
I want you to follow that with your eyes and your eyes only. Don't move your head, okay?
Okay.
The tip, up here.
The top tip or
Yep,
bottom
the top tip.
Okay.
See it?
Yep.
You don't wear contacts?
No.
No? No problems with your eyes?
No.
Alright, and you're not injured as a result of the accident?
I'm just freaked out.
Okay. Alright, follow the tip. Don't move your head. Just the tip.
Yep.
Step out, go right to the center of the road.
The line is the line. You're right here.
Go right here to the line.
Yep.
Alright, stay right there and face me.
Is that my first race?
You mentioned surgery to your knee. How long ago was that?
Friday.
Friday. Is it affecting you right now?
I mean, I'm gipping around, yeah.
Alright, at any point if you're in pain, just let me know.
Yeah.
Alright. The first test we're going to do is the walk and turn. I'm going to put you in the starting position. I want you to hold that starting position until I tell you to begin the test. You understand?
Yep.
Starting position is going to be your right foot in front of your left foot, touching heel to toe just like this.
Yep.
Hands down at your side. Alright? Do you want to take your flip-flops off or do you want to leave them on?
I'll leave them on.
Alright, so you can take that position. Right foot in front of your left foot, hands down at your side. Alright? When I tell you to begin, you're going to take 9 heel-to-toe steps forward, counting each step out loud. Upon the completion of 9 steps, you're going to keep the front foot planted, series of small steps with your other foot, and turn around. Okay, it's going to look like this. 1, 2, 3. I'm doing 3 for demonstration, you're going to do 9. Completion of 9 steps, keeping that front foot planted, series of small steps with your other foot, and 9 heel-to-toe steps back. 1, 2, 3. The entire time, keeping your hands down at your side, you're looking down at your foot and counting out loud.
Okay.
Once you start the test, do not stop until you've completed it.
Got it.
You understand?
Yes.
You may begin.
1, 2, 3, 4, 5, 6, 7, 8, 9. Ow. Keep going.
Like I explained, 9 steps forward, series of small steps, 9 back.
Ow. Sorry. 1, 2, 3, 4, 5, 6.
Good?
Yeah.
Alright. Next test you're going to do is the one-leg stand. Alright, again, I'm going to put you in the starting position. You're going to hold that starting position until I tell you to begin the test.
Okay.
You understand?
Yep.
Starting position is both hands down to your side, both feet together. Just like that.
Yep.
Touch both feet. Alright? When I tell you to begin, you're going to raise one leg of your choosing approximately 6 inches off the ground. Keep the bottom of your foot parallel to the ground, look down at your foot and count out loud 1001, 1002, 1003, and so on until I tell you to stop. Remember, you can raise either leg, whatever's going to be best for you and your knee.
Yeah.
Alright, so I'm going to demonstrate 1001, 1002, 1003, and so on until I tell you to stop.
Okay.
You understand the directions?
Yep.
You may begin.
1001, 1002, 1003, 1004, 2005, 2006. Sorry, I'm just freaked out. Like, what am I supposed to be doing again?
I'm counting it out loud until I tell you to stop.
Okay, 1001, 1002, 1003, 1004, 2005, 2006, 2007, 2008, 2009, 10,000, 11,000. It's getting hard.
Alright, you said it's been about an hour since your last drink?
About that, yeah.
And how many did you drink?
I mean, since like noon today, like 5 or 6.
6 since noon?
Yeah.
Beer or what was it?
Beer. Just beer. No light.
Alright, turn around and place your hands behind your back. I'm gonna take this watch off, okay?
Yep.
Yeah, we'll grab everything. What do you need? Your phone, your wallet? Yeah. Where's that at? Front seat, and where's your phone?
You want to put them in the back of your car? Or one? I got mine against the car. I drove up here. One of them. We got search.
I'm just search you right here, right?
This is your car, sir?
Yes. We're gonna go to that car. I'm gonna do it right here, alright?
Yep.
All your stuff in the car, the registration, all stuff gonna be in there. Where's that? Just throw them in my
What's your name again, man?
Sean.
Sean, I'm just going to read you this and use your verbal acknowledgement, okay? You have the right to remain silent and refuse to answer any questions. Do you understand?
Yeah.
Anything you say may be used against you in the court of law. Do you understand? Yeah. You have the right to consult with an attorney at any time and have him or her present before and during questioning. Do you understand?
Yes.
If you cannot afford an attorney, won't be provided if you so desire prior to any questioning. Do you understand? Decision to speak to us is not final. You may stop talking to us anytime. Do you understand?
Got it back.
Is everybody okay back there? I mean, what happened?
We'll talk about that when we get to the station.
Outside.
All right, so you guys could see that was very rural. That was actually more country than I thought, right? That was way more country. I thought it was country, but I didn't think it was that country. That is serious country. So he passes on the wrong side. All right, so he passes on the wrong side of the road, essentially. So, and I think this was. I don't think it was immediate. He tried to run away. So that was, it said 20, right? So that would have been like 8 o'clock. So I think it probably happened maybe at 6 or 7, right? I think it was probably around 6 or 7 because he said he was drinking all day. He had been drinking since noon. So. And then he left the scene, yeah. But he couldn't drive. He could only go like a quarter of a mile or something like that. He couldn't really drive. Couldn't drive his car, his Jeep. He had a Jeep. He couldn't drive his Jeep. Yeah, miles and miles of dark roads and fields down there. So I'm trying to figure out what the brothers were doing. They were going, I guess, to a country club, from a country club, wherever they were drinking. They were, I don't know why they were out there. Why were they in such a secluded area? Hey, Dillinger Arms, bot keeping you in check. I appreciate it, bot. Yeah, Kerrville, dude, he just read you Miranda, and now you ask for that. Yeah, I don't know what the brothers were doing in such a rural area themselves. I mean, they were there for their sister's wedding. They were out drinking. Guess, was there a country club? Were they staying at a hotel? Right? It seems like they were pretty far out as well. Angelique, leaving the scene of the accident just tells you the kind of person you are. Jim says they were at home, so somebody lived out there, so that's what they were going back to. So they were drinking. Obviously, they were drinking because their BACs were pretty high. So they were, it just seems like, then my question is, and trust me, I'm not victim shaming at all. I'm just wondering, why were they in a rural situation as well? Like, where were they drinking? Where were they coming from? Where were they going to? Were they with the family? Because usually the night before, you have the rehearsal dinner the night before. People absolutely are out, partying and drinking. It happens all the time. Family, maybe the event happened in town and he drove out of town before being pulled over. He said he came from work, right? He said he came from work and he was driving around drinking. He was talking to a friend. We know that. He was on the phone with a friend of his, talking for like a long time. So I would expect we'd hear from that friend. Kerviel says the brothers were just exercising off their alcohol. Yeah, that could be. That could be. MG, and it's the children and wives that suffer. In this case, the wives, yeah. So we're over half an hour now and still no feed. So see if I can find anything else we could watch. Tammy, you're just guessing? Yeah. No, I know. We don't know until we actually hear some evidence. Let me see if there's anything else we haven't seen. We've shown a lot already. Let's just see if there's anything else we haven't seen. Um, yeah, we've watched all these. We've seen all these clips before, so I don't want to necessarily show them again. Just trying to see if we can find. All right, this might be good. We haven't seen this. This will kind of show it in the daytime. Let's check this out while we wait. Oh, wait. Hold on. We may have something here, guys. Yep, we have it. Hold on. We have it. Yep, I know. I'm on it. Just bear with us for a moment, guys. Just bear with us.
Yeah. I'm telling you, when you get old, it's something. No. Old enough to go that way.
All right, good morning, council. Let's go on the record now. The matter is stated in
Stand for now.
Mr. Johnny Higgins, this case comes from court under indictment 2412-400I. Council, your appearances, please.
Good morning, Your Honor. Michael Messer on behalf of the state.
Morning, Your Honor. Richard F. Kleinberger III from the firm of Kleinberger and Nussey, appearing as co-counsel for the defendant, Sean Higgins.
Judge, thank you. Good morning. For the record, it's Matthew Portella from Haddonfield. It's co-counsel for Mr. Higgins.
Okay, good morning, council. We're here today regarding several motions that have been filed by the defense. We had a regarding the procedure for the motions. And council, I think we indicated we're going to address the discovery issue first with regard to the evidence regarding the blood draw and Brady material. Mr. Kleinberger, Mr. Portella, that's your motion. I'll hear from you first.
Thank you, Judge. Judge, I won't go through the case law. I believe we know under from Brady, Giglio, all the way down, State v. Johnson, as well as Baranski, that what is requested pursuant to State v. Heisler has all been requested in the same manner that Heisler says we can once the state makes the offer of proof that they intend to use the lab certificate. We objected to lab certificate and requested the documents that were attached to my notice of motion with regard, I believe there's a total of 19 items. We did receive a packet with many of the items. There's actually 4 areas that we need to address with regard to same. And this is just for the purpose of discovery, not whether anything would be admitted into evidence, but for the purpose of discovery. With regard to request number 5, there was the chromatograms produced from all samples, internal standards, regular standards, mixtures, and controls run in the batch in which the sample in this case, by this case meaning the gray caps that were tested, that were drawn from Mr. Higgins, as well as the linearity plots for the grass chromatography that was used for 2 years prior to the test, in this case to the present. I need those. That was number 5. Number 16 were the reports of external audits for the 3 years preceding the test in the case, and any time since the test in this case of the section of the laboratory performing this test was used in this case. With regard to 19, Judge, and I don't think it was clear from my request, but it was when it says test the blood in the case, it should have been persons. That would include any training records, the CV and resume. That would also include the phlebotomist. Under Baranski, it is permissible for anyone who has to testify with regard to the chain of custody, that request as well. What I'll do for those 3, Your Honor, is I will reduce them again to writing, break it down, send it to the state. If we receive it and our expert has it, then it's a non-issue. The last area of inquiry, Judge, had to do with the blood testing procedures and results of the cyclist matter. And I don't understand the state's objection, but it says they object as those documents are not in the possession, custody, and control of the state. The autopsy was conducted at the Gloucester County Medical Examiner's Office, and blood was taken and sent to an independent lab that did the analysis. For the state to say that they have no control or jurisdiction of the lab, it makes no sense. In fact, by the state placing that on the record, it's going to open up a wide barn door for attack as to anything then relating back to the autopsy and toxicology testing that was done if the state claims they don't have control over it. The state hires them. Whether the state hired them directly or the state hired them through the office of the medical examiner, it's an arm of the state. They have control. These are documents that we have every right to. It's part of the evidence that was placed in at the grand jury. And if it was evidence that was placed at the grand jury, we should be entitled to look and see what is behind the door of that evidence rather than something at face value. There's reasoning behind it. I could touch upon some of the reasoning without showing a hand as to what our experts may say. But the main thing, Judge, is to look at the difference, if there is any, between the procedures and protocols of the one lab and the other lab. Also to see the handling along with chain of custody, because under the State Police Evidence Field Manual as of April 2024, with regard to the police evidence tracking system, as well as their forensic trace evidence system through the Forensic Biology of New Jersey State Police, there's a checklist when it comes to packaging, marking, sealing, transportation. I need them for both. Our experts need it for both. Again, if it was a piece of evidence that was never brought up, that was never utilized, I would say it's a different animal. But if it was brought up at the grand jury, I do believe it's proper. And I don't understand if the state means that they don't have control over it. It's a piece of evidence that they put into testimony. We're entitled to what is behind that evidence. And Judge, that falls under Brady, Giglio, because it's not just discovery that would be exculpatory for a defendant, but also any discovery that could be utilized for the purposes of impeachment at trial. And we have to remember that we're not limited here. This is not, Brady, Giglio, and the rules as to Baranski that have been cited throughout this brief do not limit what a defendant can get, but rather expands. Based upon that, Judge, I believe that request is proper. I'll defer to the state for their argument this time.
Thank you, Mr. Parker.
Your Honor, with regards to the blood evidence regarding the defendant, the state did hand over an extensive packet that substantially comports with the request that was requested. There's just a tying up of loose ends on that. With regards to number 5, I did talk to the officials at the lab. They indicated, for lack of a better word, that request was gibberish. They couldn't make heads or tails of what that request was. So once they get clarification, and I believe counsel is going to give clarification of what that they're requesting, I'll give that to them, and then we'll go from there.
So, referring to Mr. Metheny, the request regarding the chromatogram.
Correct.
Yeah, but it's standard, Judge. I get this in every blood case I've had in 30 years of practicing, and since it's under Heisler, it's one of the pieces of evidence that we are entitled to. So I'm not sure why there's a confusion. If there's a report that was done by the lab or anything in writing, I would like a copy of that as well so I could clear up any confusion. But I don't understand. This is a standard request that is made in every single blood draw case that I've had in the state of New Jersey. I need chromatograms for 2 years prior to the test, and then those from the test to the end of 2024. That's it.
And Mr. Kleinberg, I don't believe the state's objecting to that.
No, but they're saying they didn't understand what it meant.
Before I was interrupted, I just indicating that we are going to get that once I get clarification. So we're taking care of that.
It's a chromatogram.
To the lab, the documents regarding the lab, the certification of the lab, that's done by an independent company. The most recent one, they're waiting for that certification to come back. Once that comes in, it will be turned over to defense. The CV for the chemist that did the testing of the blood, that was turned over in the initial discovery way back when this case was first charged, when we got the initial discovery. And when we got this extensive discovery packet put together, it was turned over again. As far as the nurse that did the blood draw, I'll get the CV for him as well and turn that over. We are also doing the background check for the chemist that did the testing of the blood. Once I get that from the state police, it will be turned over in due course and given over to defense counsel. So I believe that portion of the discovery request has been and will be taken care of.
So just for clarity, the three numbers on Mr. Kleinberger's request, which are 5, 16, and 19, are all actively being addressed by the state, other than 5, which Mr. Kleinberger, you're going to provide a more, I guess, clarify the request that Mr. Messenger can turn that over to the lab to get this documents.
Judge, I'm going to ask for the chromatograms for 2 years prior, up until the end of 2024. And for the external audits, I understand that the current one has not yet been prepared to win that, but we have not yet received the other ones requested for 3 years prior. So I need those as well.
They're in the discovery.
All 3 years? Because there's 1 year. I thought there was 1 year missed 2024.
I believe they're all in there.
Okay, I'll check again.
Check again. If you don't see them, I'll check with it. It's a matter of us talking after work here. If they're not there, I'll talk with the lab and see if we can get that.
I'll ask counsel to confer with each other, review your discovery. Mr. Messenger, you review what you have. You find things that maybe you didn't turn over. By some.
And understandably, there's 491 pages of discovery that was turned over. And a lot of it's technical documents.
So what I'll do is just check on that. I'm going to reserve on the motion to the extent that it sounds as though you're both in agreement with each other as to the documents that need to be provided. I'm not going to sign an order since it seems like they're both cooperating with each other.
Right.
However, I'll ask that Mr. Kleinberger, if you don't get the documentation that you need, reach out to the court. This would not have to be relitigated. I'll just prepare an order based upon today's argument. That can be done on papers.
With regard to number 5, once I get that letter from counsel, I'll provide it to the lab. If in that letter, again, they say they don't understand, counsel can have their expert reach out to the lab and they can have a discussion regarding that. They said that they are open to having their expert contact them and having a discussion about what they're requesting.
Judge, just so I'm clear, it's a chromatogram. They're in every case.
We understand. I understand that.
That's all I want.
And the lab has indicated that these requests are read, despite what counsel has represented today.
Judge, this was taken out of Heisler, but
Any further issues in that regard?
not for that, judges.
So at this time, I'm not going to sign an order. Once again, to continue to communicate among yourselves, get that information. There's problems going further. Just advise the court will. The next issue we're going to address is Mr. Kleinberger. You also made a motion to compel the state to produce plea offers to waive.
No, Judge, we didn't address the blood evidence from the. I made that argument, Judge.
Your Honor, with regards to that, Court Rule 313-3 1BE indicates that I only have to turn over discovery that's within the possession, custody, or control of the prosecutor. The discovery that he is requesting is from an independent lab. Again, the defense has equal access to that lab. I don't intend to use any of that evidence during trial. It involves the blood alcohol or the blood analysis of John and Matthew regarding their autopsies. It's the state's position that that's not relevant to this case. It won't use any of that in the state's case in chief. If defense wants to use that, they can, if it's deemed relevant by Your Honor. If they want to get that discovery, they have just as much power to subpoena that independent lab to get that discovery. But this, it's not the state's responsibility to get that discovery for them.
Judge, if I may, if the state is taking this type of position, then that would mean that in any case where an outside lab, such as the one in this one, was utilized, and the state goes to move into evidence, for example, the autopsy report, and part of the autopsy report references this testing that was done. I think the state is now admitting on the record that they do not have proper chain of custody then for their reports that are going to go in. And therefore, there's going to be an issue. If the state says they don't have control over the lab that they hired to do that part of the case, and that evidence already came into grand jury, then there's going to be an issue there as to chain of custody when it comes time for trial. Because you can't just take something as a net opinion as a whole and say, well, this is what the opinion is and we're going to put it in. Rule 313.3 does not control all discovery. Again, as stated, Brady, Giglio, the other cases that I cited, Bransky, Heisler, discussed the expansion of what is given to a defendant in these cases. And it does not, whether it's relevant or not for the time of trial is not a discussion for now. It has nothing to do with right now. It has to do whether it's relevant as to if that is a piece of the puzzle that goes into the report, the final autopsy report, then we're entitled to the recipe, not just the finished product. And that's what we're looking for, is everything that went into it. I think it's proper. I've never had this issue before. I've had other homicide cases throughout the state where this same exact lab was utilized and the state had no problem getting me the documents that were needed. When I needed the toxicology reports and the basis behind it, I received it. So I'm not sure what the issue is here. Is it that did they attempt to? Is there a letter that shows that they attempted to and they were told we don't have it? Or is it not my job and just let it go? If that's the case, I'm just going to place on the record right now, I'm going to object then, and I'm going to place them on notice that anything as to chain of custody that has to do with the cause of death and autopsy report will become an issue in this case. Because if they're saying they do not have the ability to control their expert that they hired as part of that puzzle, then that report should not come in. I believe we're entitled to that. We're going to have our own medical examiner look at everything. And I think it's important that our own medical examiner have the access to these files.
Mr. Clever, I think the state's saying you're not intended to. I think they're saying you can obtain an intended.
Correct. And I'm not saying I have no control over this lab and this lab is running wild. I'm just saying that I don't intend to use these lab results at trial. I don't deem them relevant for the state's case in chief. If defense wants them, they have just as much control over this lab as the state. If I wanted these things, I could go out and get them. I could ask them for it, but I am not using them at trial. So if defense gets them, I could ask defense for reciprocal discovery, and I am entitled to them if defense intends to use them at trial.
So your position is you don't have them and it's not your intent to use them?
Correct.
But if they're using the...
And the defense is arguing if I'm going to use it, then chain of custody is an issue and they shouldn't be able to use it. Well, that's a
weight of the evidence.
Correct. Exactly. Not an admissibility issue.
But not just that, Judge. That's one of the issues. The other issue would be if they go to move the autopsy report in for that, and then the medical examiner on the stand, and I cross-examine him as to items that are in the report, including the blood alcohol level of, I believe it was a 0.129 to 0.137, and go over that. I do believe then that's going to be an issue, that I'm entitled to that. If it is part of the autopsy that was done, it should not just, here's the report, That's the end of it. In every other homicide case I've ever had where there's an independent medical examination done of the cells or anything that was done, including blood and other toxicology, you are granted that evidence, the meat that goes into the meal, not just the end result itself. To say that, well, we're going to plan on using the report, but you're not entitled to, not that we're not entitled to, we're not going to give you what are the state's expert used as part of the basis. I just want everything that went into that report. If I have to make a separate motion for it, I'll make a motion then I will break down the medical examiner's autopsy report, and I will cite for the court, line by line, each piece of evidence that I need, and I will cite case law for each piece of evidence that I am requesting, and I'll do it that way. I'm trying to short circuit it by making a part of this motion, since we're talking about blood and serology at this point. I thought it would make sense, and in the interest of judicial economy, to put it in with this. But I can make it a separate motion where I will take the medical examiner's report, break it down, and say I want A, B, C, D, and cite the case law behind each.
Mr. Smith, do you find the unduly burdensome on the state department?
Your Honor, I don't know how much of this discovery, it's for just the defendant, it's 491 pages. And then he's asking for the same discovery for two other individuals.
Yeah, I don't think he's looking for that much.
It can't be the same because there's certain things that common sense would dictate don't apply. For example, I don't need the gray caps and the barcode because there are no gray caps in this type of situation. I don't need the phlebotomist because there was no phlebotomist. I don't need the CV of the individual who drew the blood. So, I mean, if the state wants, I'll go through the standard list and say, obviously, this doesn't apply. I could do that if they want, but it's not the same discovery because it would be impossible. It just doesn't exist.
You're just seeking the information from the independent lab.
Correct.
So it's a different discovery request. If he wants to submit a different discovery request, again, I'm not using these things. He has the same access to this lab. I don't know why it's the state's burden to produce discovery for him that he's going to use that discovery when it's not the state's lab. It's an independent lab. I don't know why it's the state's burden to produce this discovery for him.
Mr. Clemmer, you continue to refer to the lab as the state's expert, but the state did not retain this lab as an expert.
No, but their witness is going to testify, utilize that as part of the net opinion for his report. It goes in, it was part of what was done for the report. So again, what I can do, Judge, I will gladly take the medical examiner's report, we'll break it down, and I will put in piece by piece what I'm requesting and cite the case law and do it that way.
Because I guess the next question will be what relevance for
it would be for our own medical examiner to look at everything, the protocols with regard to it.
I think you need to establish relevance in order to get this material, unless you want to get it independently, but you can't.
The relevance would be, Your Honor, as to A, cause of death. And again, I don't want to get into beyond it, but whether or not there was any intervening factors, I don't know because I don't have everything as of yet. The only reason I added that one requested for right now was because I was already making a blood request with regard to Mr. Higgins. I do anticipate some point in time requesting additional information with regard to the medical examiner's report, and I may need other things from that for our expert. So it doesn't make a difference to me either way, whether I do it now or I do it then. Either way, I'm going to request it again with the case law and explain then specifically as it pertains, not independent by itself, but as it pertains to be part and parcel of one of the building blocks And whether it's a foundational that if you take it away, the whole castle topples, or it's just a piece that's decorative, for lack of a better word, where you take it out, it doesn't make a difference. We're entitled to that, what went into the meat of that report, to break down to see if everything was done properly and if there's something that was missed. Wouldn't be the first time in the state of New Jersey that an independent medical examiner reviewed something and found something new, different, or an error. So we could either do it now, or as I said, Judge, I'm coming back anyway to file for the additional request with regard to the medical examiner's report. I can make the motion then as well, or I could simply get a subpoena in Montgomery County, Pennsylvania, and go that route. It doesn't make a difference. If the state doesn't have it, if they don't have it, I'll make it part of the motion then for my next motion with regard to the medical examiner's report. But I would appreciate if the state had, and this goes back to request for number 5 and request for number 16, if the state has any correspondence between them and that lab, I would like copies of the correspondence between them with regard to when the request was made, what was made, and what the issue was. If it was all verbal, that's one thing. But again, my antennas went up. One of it with with either MS Lab as well as New Jersey State Police, because if I'm being told that they don't know what a chromatogram is, I'd like to see what they said in their writing, because I think that's kind of confusing.
Yeah, I suspect that would not be the response.
Right. I just like to see what. Okay. So again, if the state has any communication, that'd be helpful. But with regard to that last piece of evidence, Judge, we could make the request now and handle it now, or I can make it part and parcel of my upcoming motion to anticipate.
And Your Honor,
I suspect it's the state's position that the ME's report would seem to reflect that the BAC of the victims is extraneous information and was not relevant to cause of death.
they're doing their due diligence. And so to say that their BACs may have contributed to the cause of death is a bit upset. Is a reach, to say the least. Your Honor saw, I'm sure Your Honor read the grand jury presentment. You're very thorough in your preparation for hearings like this. You read the extent of these injuries that these two men suffered during this accident. BAC was not something that contributed to their deaths. This is kind of like a red herring, Your Honor. And defense talks about judicial economy. All they have to do is do a subpoena to this lab and get what they want. That's all they have to do. So they can do that, and if they want to do that, they can do that this afternoon, and they'll get what they want.
And again, Judge, just brought up the grand jury, the piece of evidence that they brought up. I do believe we're entitled to it. That's all. And we're not saying that it was. I'm saying examiner has not looked at it yet, and I'm not sure what medical school Mr. Mester did. I did not go to medical school, and I am not that smart that I can make a determination by looking at a med opinion or pieces of a discovery and say, well, this is it. Again, it's not the first time in the state of New Jersey where we have had a medical examiner second guessed and proven wrong, regardless. I'm not saying it's the cause of death, but I don't know what impact it had, if any, without having it. If it's an issue, I'm going to make a separate motion with regard to the medical exam. That's all.
I think Mr. Messer's position, if it's that important to the defense and it's available to the defense can opinion on some.
Correct, Your Honor.
Anything further in regard?
No, Judge.
Then to the next issue. Now,
Judge, next issue had to do with the request with regard to additional plea offers that have been made. As Your Honor recalls, there was a phone call between the state and co-counsel with regard to a plea offer. Thereafter, we then received a written plea offer of 20 years. The state then said that plea offer of 20 years in writing was an error, that the plea offer then was a offer essentially of 35 years with regard. While researching that issue, and I'll agree that there's no motion, or will there be a motion to try to enforce the plea offer of 20 years, it became apparent through discovery outside of the courtroom, as well as through a simple search, that within the past year, there were at least three that we know of, plea agreements made by the same prosecutor's office with regard to individuals that were charged with the same thing, except in one case, in the October of 2024 matter, the driver in that matter had a blood alcohol level of a 0.22, almost 3 times that of Mr. Higgins, and also was smoking marijuana. I do believe also had a 3-year-old child in the backseat. Also hit a cyclist by going into the cyclist lane, and had to be stopped by a fire truck as he kept fleeing the scene. In that case, that individual, I believe was in front of Your Honor, was sentenced to 7 years with 85%, based upon a plea agreement state. Prior to that, there was also a matter of David Thomas, which was Judge Lawhon, where there was a term, 1 year was for a term of 4th degree assault by auto, where Mr. Thomas killed another motorist while 3 of his passengers and the first vehicle struck were injured. He had an open container in the car. And his blood alcohol level was a 0.156, double that of Mr. Higgins' alleged BAC concentration, and was traveling at a high rate of speed before that. Again, that was sentenced to a concurrent term of 4 years, each on a 3rd degree assault by auto and a 1-year term on assault by auto. So I do know that there was another matter of Stephen Krowski, who killed a motorist, where he had a blood alcohol level of 0.122 and was traveling at a speed of 113 miles per hour before the crash, and 70 miles per hour at the moment of impact. And again, Judge, I do understand that this is a unique request with regard, and part of the reason behind it is, with all due respect, and understand there's cameras here, so it's a case where it's a little bit different, but justice is supposed to be blind. And it's supposed to be blind when we're looking towards a defendant or when we're looking towards a victim in a case. There should not be a special category because it's a high-profile case that state is treating this one differently than a case they had just a few months ago in this very court in front of Your Honor, with worse facts and circumstances. And it's the state's obligation. The prosecutor's office represents the state of New Jersey. This is not a civil case where they're representing the estate of the victims. I do understand there's victims here. And from the process that we've had thus far with regard to the issues with discovery and getting things moving along here, I do believe that it's proper, at least, and if the state does not want to turn it over and Your Honor does not want to turn it over, again, I understand. I could easily continue to go through Promise Gavel and look at every plea offer that has been made. Not offer, let me repeat that. Every plea agreement that has gone through and been made with the same type of case, and as I cited in my motion and my notice for that request, I just, for the sake of clarity, would like to see what the difference was in a case where we are now seeking 5 times the amount than that of when a school teacher is killed and a 3-year-old child is in the backseat. I understand that this is not something that's normally requested. With regard to my brief, Your Honor, I did cite, though, one of the things that is very important in all trials, and as I'm sure the court is aware, because I do believe that last year I think there's a total of there are at least 5 jury trials that were heard in this county. Most cases, I'm assuming then, are resolved by way of plea bargaining. And how do we get there? It has to be something that is fair, even-handed, on the level playing field. And at least I understand that there is no one objective way of saying that every case is the same. I agree that there are certain aspects that go to the mitigating and aggravating factors that Your Honor considers and weighs at the time of sentencing. However, leading up to that, when it comes to the negotiation, we have a situation here where it does seem that 97% of all cases are resolved through plea deals in this state. And you have to have a mutuality of advantage here when it comes to both the state and the defendant. And when we have a situation where we're told it's 35 years, and then you receive in writing 20 years, like, no, that's a mistake, it's 35 years. And then you know, as a practicing attorney in this county, that other cases are going through it 7 years. There's an issue, and you have to say, well, what is being treated differently here? I understand it's 2 victims. If they said 15 years, if they said 20 years, I would understand that. But when we get to 35 years, which essentially, with all due respect, if my client were to stand up and represent himself in front of the jury and be found guilty, that's most likely what he would get anyway. So it's really not a plea bargain. It's a take it or leave it. We're going to trial on this. And I don't want to talk just about fairness to the defendant. I want to talk about fairness to the victim's family as well. Because when you put it in such a posture that you're forcing a defendant to go to trial, that then puts an additional burden on the state as well as the family of the victim, because for whatever reason, the state is not using the same playing field that they used in other cases. So again, if the state says Mr. Kleinberg could just as easily go through promise gavel and get it, and the court says the same thing, I'll do it, and it's fine, and I'll still use that, and I'll still negotiate in good faith, as I always have in this court and every other court in this state and other states I practice. I'm asking for it. The state has it. If they say it's equally accessible to me, I'll go through the trouble of getting it, and that'll be it, Your Honor.
I guess the question, Mr. Kleinberg, is, and you've been practicing law all the time, plea negotiations, you always get it all. And in response, typically there's a counteroffer. I know in your situation, defense is not prepared at this point to make a counteroffer. But just because a plea resolves at a certain number doesn't necessarily mean that that was always the state's first offer. And it's an ongoing process. It's a give and take. As the tide shift, the offer shift. So the fact that they started out where they started doesn't necessarily mean they're going to end where they end, which to me then creates an issue as to what relevance there would be as to the final plea that's perfected on the record. In other words, some pleas where there was a 7-year plea on the record, the offer may have started at 30. I don't know where the offer started. Mm-hmm. So what relevance is there as to what the initial state's offer was? The state hasn't, at least Mr. Mester hasn't indicated he's drawn a line at saying and said 35, take it or leave it. This is our best and final offer. And I'll let Mr. Mester speak.
Judge, let me ask about that though, just so you understand. When you ask what's the relevance, when it does come to the plea bargaining, and as much as I like to hold my cards close to my chest, I'll show the cards right now. The idea is this: I believe it would be beneficial for both the state, and the state could show to the victim's family, hey, over the past 5 years, these are cases in our vicinage, which is what I plan to do, not just Salem, but in the vicinage, where there have been similar cases that have either been pled out or gone to trial, and this is what happened. My idea is, in this matter, to go through and put at least a list together where the state can weigh out and see the similarities and differences, as well as look at the mitigating and aggravating factors in this case, and explain as well as to the victim's family, this is why we're coming to this number. Again, if the state says it's just as easily accessible to me, I'll take the extra few hours and do it. I don't mind hard work. I'll do it. It's not an issue. That's the relevance behind it. That's the reason behind it, Judge.
First off, I want to address, counsel indicated that there are victims here. There aren't victims here. There are victim survivors here. The victims are not here. They could not be here. And with regards to this motion, counsel knows that he has access to what he's asking for in Promise Gavel. There's no need for this motion. And the fact that he put facts on this motion in this very public case, drumming up similar cases, reopening wounds for these other victim survivors is a bit offensive and unnecessary. It is clear defense does not like the initial plea offer. If counsel does not like the initial plea offer, they can do what defense counsel does in every case in the state of New Jersey. They can tender a counter offer when they feel they have enough evidence and have an argument to tender a counter offer. In their brief, they cited 19 cases, federal or state cases, to support their argument for Your Honor to compel the offers. All of them deal with the actual pleas in those cases, not the offers in those cases. None of them require Your Honor to do what counsel's asking Your Honor to do. If counsel doesn't like the offer, they can tender a counter offer. Now, with regards to what I do or don't advise victim survivors, that's between me and the victim survivors. I've been with them for hours going over this case and what is entailed with this case. They are aware of what this case is going to be, one way or the other. So defense counsel doesn't have to do any of that. He doesn't have to worry about on his end. So it's fine. So I don't think Your Honor really needs to grant this motion. Again, if counsel wants to tender a counteroffer, he knows my phone number, he knows my email, he knows where my office is.
Thank you, Mr. President.
And Judge, once we have all the discovery, I mean, this is since we're only 6 months into it now. I'm hoping we have the discovery soon. We will be able to rationally, intelligently, and properly do a counteroffer with all the evidence at that point.
Thank you. I did prepare some notes after I reviewed both of your submissions in this regard. I'll make the following comments. Pleas were taken in open court, typically public record. We have open. They're not protected as far as what the ultimate result was. Plea bargain comes before the court. Once again, defendant's free to obtain this information from court. Court has a mechanism by which the defense can look those cases up and find the nature of every single plea that was taken by the court. The state is in a good position to furnish that information, but I don't know that it has any relevance as far as ultimate outcome of the case with respect to whether, you see, it's clear it would never be admissible. Court counsel could never stand up in front of a jury and argue to a jury, well, in State versus Smith, the state offered the defendant a 7-year sentence, but guilty of 7. But in this case, they only made us a 35-year-old. Everybody knows that obviously that doesn't happen in court. So the relevance would be merely, I'll call it for exploratory purposes to see what the state proclivities are in similar cases. But that's something, once again, doesn't fit the rules of evidence. It should be something the court will consider relevant in a hearing or a trial. And as counsel is aware, the court has to look at each case on a case-by-case basis, as does the state, as does the defense. Everything is predicated upon a certain set of facts and circumstances that emanate from an incident that occurred which resulted in a criminal charge being filed. They're all different. Not one is the same, like Snowden's. So when we're looking at everything in its totality, I don't see that there's an adequate basis that's been established by the defense to help the state to turn over this information. Once again, plea negotiations, as I indicated, are ongoing. The state makes their original offer. The defense can counter, at which point the state can come back with the second offer. The defense can then recounter. Ultimately, we see many cases get to the point where, based upon those ongoing negotiations, we get a resolution. There are, as Mr. Feinberg pointed out, 3% cases in the state of New Jersey do end up at jury trial because, for whatever reason, the state and defense can't come up with a number that satisfies both sides. So under the circumstances, based upon everything that we're looking at, I'm going to deny that motion to compel. I don't think it's appropriate. I don't think it's proper. That irrelevance. However, once again, it's free and public record. The state defense is obviously entitled to do their own exploring and find out any prior cases that this court has heard or any court in this nation. Find out what the offers were. I'm actually not what the offers were, but the ultimate perfected plea was. So for that reason, I'm denying that. At this point, we can move on to the state's defense's motion to dismiss.
Since we're going to have,
I'm just going to switch.
sure you can switch. Okay.
Oh, yeah. Judge, thank you. And good morning. Good morning to everybody in the courtroom. Judge's defense's motion to dismiss the indictment. We submitted briefs on it, Judge. I'll frame the argument, frame what the issue is here, and that is the state presented to the grand jury on December 11th, 2024, the charges in this case. And the original charges were of importance were the leaving the scene, but more importantly, the second degree vehicular homicide, death by auto, or reckless vehicular homicide. After the presentation, Judge, the grand jury returned a true bill for 6 counts, 2 for first degree aggravated manslaughter, 2 for second degree reckless vehicular homicide, 1 count of fourth degree tampering with physical evidence, and 1 count of second degree leaving the scene of a fatal accident. Judge, the first focus to frame this is on the presentation, the dismissal of the 2 charges or 2 counts of first degree aggravated manslaughter and the 6th count for leaving the scene of a fatal accident, Judge. The reason for that is under State versus Hogan, there's an argument to be made that the state failed to present a prima facie case of each element of aggravated manslaughter, that the state failed to present a prima facie case for leaving the scene of a fatal accident, and that the state presented what the court in State versus Curtis said, a distorted version of the facts by presenting only half-truths to the grand jury. And the grand jury, Judge, in the scheme of the criminal justice system, is the first step after charges for the state to move the case forward along. And it's an important function. It's one that's guaranteed by the Constitution to all defendants. They all have a right to have the case heard by a grand jury. And what is the grand jury's role, or what is the state's role, Judge? And that is, in seeking an indictment, the prosecutor's evidential obligation is to present the prima facie case that the accused has committed a crime. And nevertheless, in establishing a prima facie case against the accused, the state may not deceive the grand jury or present evidence in a way that is tantamount to telling the jury or the grand jury a half-truth. And I'm going to quote this, Judge, from State versus Hogan at page 229, and that is, the grand jury cannot be denied access to evidence that is credible, material, and so clearly exculpatory as to induce a rational grand juror to conclude that the state has not made out a prima facie case against the accused. If evidence of that character is withheld from the grand jury, the prosecutor, in essence, presents a distorted version of the facts and interferes with the grand jury's decision-making function. Judge, there's case law out there. There's an analogy that the grand jury is not only a sword for the prosecutor to move a case along, but it's also a shield to protect the defendants and the accused from overzealous prosecution or overreaching by the prosecution. So, Judge, let's start with the aggravated manslaughter counts, which are counts 3 and 4 of the indictment. The elements that the state needed to prove or present, not prove, Judge, but present to the grand jury of aggravated manslaughter is that the one, defendant caused the victim's deaths, that 2, the defendant so recklessly did so, and 3, the defendant did so under circumstances manifesting extreme indifference to the human life. And those are 3 elements, Judge. We concede the first one, that the defendant caused the victim's death, and that's based upon the autopsy reports. That the defendant did so recklessly, and Judge, I'm going to concede that just for this motion. The reason for that is under the reckless vehicular homicide counts in 1 and 2, the recklessness element was that Mr. Higgins had driven under the influence, because there's that certain section in that statute that when somebody is driving in violation of that statute, 39:4-50, that rises to the level of recklessness, where a state could then prove a case for the second degree charge of reckless vehicular homicide. But the third issue here, Judge, or the third element, is that the defendant did so under circumstances which demonstrate that the defendant's conduct was done so under circumstances manifesting extreme indifference to human life. And that's where we go the difference between a second degree death by auto, where there's just recklessness or drunk driving, to a higher element or a higher crime or a more severe crime of aggravated manslaughter, which needs to take into account, Judge, the drunk driving or recklessness, and then recklessness that is so high that the defendant's conduct would probably have caused the death of another person. Not mere possibility. It rises up to the probability, Judge. And that's in State versus Curtis in the appellate division, Judge, from 1984. It's the risk that the defendant caused by his conduct, which is the factor. It's not what's in his mind. It's not his intent. It's not his intent to patch somebody. It's the conduct. When you look at it objectively and rationally, did the conduct rise to the level of extreme indifference to the value of human life? Here, the facts of the case, which have been brought out in court through motions, has been put out all over the globe in social media and also through the press, Judge. The facts are that Mr. Higgins was driving home from Taco Bell around 8:30 at night. It was dark. The the evidence that we have so far in discovery shows that the two bicyclists were on the right side of the road, riding their bikes on the shoulder. And the shoulder, Judge, is less than a foot wide. So it's not even really a shoulder. It's just the side of the road. As Mr. Higgins was driving, the speed limit was 50 miles an hour. There were two cars ahead of him, a Ford Focus and then a Ford Bronco. Mr. Higgins, as the grand jury heard, said that he was traveling about 30 or 40 miles an hour, or maybe 30 or 20 miles an hour, coming up because he thought the other cars were going slowly. And he sped up, as you see people often do to signal to the other people, you got a car coming up, you're not going the speed limit. He goes to pass the Ford Focus on the left lane, which was allowed. It was Trooper Pope, the grand jury, the presentation said it was a dashed yellow line. So there's no extreme recklessness or any recklessness in passing that car, Judge, although witnesses said that it came up at a high rate of speed, but we don't know what the speed limit is. We know that the one car, the Ford Focus, was driving at around 50 miles an hour. Mr. Higgins passes on the left, and he tells the police, but it's not presented to the grand jury, that he went back to the right because the Bronco, the second car, had moved over into the left as Mr. Higgins was passing the Ford. So what he did was, not knowing what that Bronco was doing, he went back into the lane. The state presents this as he was trying to pass the Bronco on the right. However, what Mr. Higgins explained to the troopers was, that Bronco went left. I don't know if he was trying to stop me, not sure what he did, so I went back into the lane. And unfortunately, when he went back into the right-hand lane, Judge, that's where the two bicyclists were. And it was an immediate impact. Mr. Higgins did not see the bicyclists because he was passing the one car, and the state had pointed out that there is a statute under Title 39, and I think it's 39:4-10. In that realm, Judge, that bicyclists are supposed to have reflective gear on, and that's statutory, and not reflective gear, Judge, lights in the front, lights on the back, but then there's also added protections. And for the record, before I go any further, and this can just address concerns of the state and the public, Mr. Kleinberger and I are not blaming the two bicyclists for the incident. That would be ridiculous. That would be wrong. However, as Mr. Mestern said, defense attorneys are doing their due diligence. We're required to do this, sometimes this fishing expedition, as we call it in the law. We are required under the Sixth Amendment to investigate cases. We are required under the Sixth Amendment to provide effective assistance to our clients, to those who are charged with crimes. That's what we are doing. We are going through the motion practice solely and primarily to make sure that we do our jobs as defense attorneys to uphold the Constitution. Not to fight about blame right now at this part of guilt or innocence, Judge, but it is to protect Mr. Higgins under the Constitution, to make sure that he gets a fair trial or he gets a fair shake at the defense. So that's what we're doing here, Judge. So as he pulls back over, the two bicyclists are hit. Unfortunately, they pass. The car that he's driving, his Jeep, is then disabled because a wire from one of the headlights had popped off. It caused the car to stall. We know that because Trooper Pope, on behalf of the state, did an accident reconstruction and said that the Jeep would stall out if all the wires were connected. Indeed, that's what happened here. The incident caused the Jeep to stall. And then it traveled, as the state continues to point out in its brief, 0.2 miles or 1,500 feet. And then the state alleges that the defendant did that to leave the scene of the accident. If we go back a step, Judge, there was evidence that was presented to the grand jury in Trooper Pope's report that they reconstructed or tried to imitate what happened that night. with the 1,500 feet. Trooper Pope took an older troop car, went out onto the road in the area and drove it to 50 miles an hour, and then put it in neutral, or took his foot off the gas and let the car coast. That car went 4,500 feet, just going and going and going. And what Mr. Higgins traveled was 1,500 feet. The state was harping on that, and I'm going to get into this later, Judge, when I talk about the dismissal for that aspect of it, Judge, that was evidence that he was leaving the scene of the accident. The state then cites cases that say, and I believe one is, I'll say the name and I'll say it wrong, Radziwill. And in Radziwill, they say that a jury may infer that an individual who drives while intoxicated, and this is getting back, Judge, to the aggravated manslaughter, the jury may infer that an individual who drives while intoxicated is consciously disregarding the risk of an accident and acting with extreme indifference to human life. The state would then proffer, Judge, that this is what Mr. Higgins did. However, Judge, when you look into the cases of Radziwill and some of the other cases, the intoxication level of the defendants was so high. And these are in the cases of State versus Johnson, which the prosecutor cites, as well as one other case, Judge, where, and I'll say that on the record, is State versus Machuzak, Machuzak, where they're saying that the intoxication in and of itself could be the extreme indifference to the value of human life. The problem, though, Judge, with those two cases are incredibly distinguishable from the fact here where the court was pointing out at great lengths the fact that the defendant in both of those cases was severely intoxicated. There was evidence that that he was acting belligerently, that he was being loud, he was obnoxious. In the one case of there was a defendant in a bar, and they developed a record that he had a habit of going to the bar almost every night and getting hammered, for lack of a better expression, to the point where both of the defendants were so severely intoxicated that the court found that could be an extreme indifference to the value of human life, where in this case, as we all know, Mr. Higgins' blood alcohol concentration was a 0.087. He went 0.007 over the legal limit. There is testimony from Trooper Pope that said that he spoke to Mr. Higgins' wife after the incident. She said that she had spoken to Mr. Higgins on the phone, and he did not seem drunk at all. She attributed things in the case to potential impatience. So we've got now passing on the left of the first car, which is proper. We've got drunk driving alleged, but it's a 0.087, which is a lower level. We've got a dark road. We've got bicyclists on a very small side of where they are allowed to travel, which they should only do during the daytime, Judge, and I'll get into that. We don't know the actual speed of the vehicles. We do know that Mr. Higgins just coasted afterwards and then stopped, and we'll get into the fact, Judge, that he actually stayed at the scene and did the field sobriety tests. And at that point, Judge, all we have is the vehicle coming up at a high rate of speed and then passing properly. The state states and presents in the grand jury transcript another aspect to bring the case to the extreme indifference to the value of human life is that Mr. Higgins' car went halfway onto the grass off the road. And three of the witnesses testified to that at the grand jury, which I attached, Judge. I think that's Exhibit C on my brief. And also in the grand jury exhibits, we see Mr. Higgins' Jeep afterwards at its resting point. We could see the 360 degrees from all the different pictures, Judge. There's no mud, And it rained later that day, but at the time of that night, but at the time of the accident, it was drizzling and the ground was wet. There's no mud on the car or splatter from the mud showing that if he was driving at such a high rate of speed, it didn't kick up any of the grass. It didn't kick up any of the dirt on the side of the road where the witnesses said he drove. And of particular importance are there's photographs that don't show any tire marks whatsoever. In fact, Judge, there's an issue here about where the actual point of impact was. On the road, out of this small shoulder, off of the shoulder. We don't know, Judge, because Trooper Pope didn't have the empirical data that he saw at the scene to find that and to give a conclusion on that. Okay, Judge. So that's what's presented. Furthermore, it's presented about the fact that he was intoxicated, but I dealt with that, Judge, under Radziwill. Judge, another factor that a court considers, and this is where I'm looking now, Judge, at State versus Radziwill at page 863, is that it talks about relevant circumstances being objective and not dependent on an actor's state of mind. Radziwill then quotes the bogus matter, State versus bogus. They upheld a conviction for aggravated manslaughter based upon evidence that the defendant drank, and I'm going to quote, to the point of being severely intoxicated, and then drove his truck on a main thoroughfare at an excessive rate of speed, proceeded into the intersection in the face of a red light. The court stated that the jury could conclude that the decision to drive and the manner in which the defendant operated his motor vehicle indicated a complete disregard for the lives of others. You get back to Radziwill, the court says similarly, the evidence in this case provided sufficient support for a conviction of aggravated manslaughter, that the jury could have inferred from witnesses' testimony concerning the defendant's habit of becoming intoxicated at a particular bar on the weekends, that he was highly intoxicated at the time of the accident. The jury could have concluded that one of the witnesses' testimonies was that the vehicle was struck from behind by the defendant's vehicle, traveling at a high rate of speed, and that the defendant did not have control over his vehicle. These are the parameters, Judge, that courts have set out under particular sets of facts that would justify aggravated manslaughter, which are lacking in this case, Judge. There's no evidence in this case whatsoever that Mr. Higgins did not have control over his vehicle. In fact, he had such control over the vehicle, Judge, that he went to move away from the Bronco because he didn't know what the Bronco was doing and properly pulled into that right-hand lane. The next question becomes, well, how fast was he actually going? Well, if he was going 50 miles an hour, which is the posted speed limit, then his Jeep, similar to Trooper Pope's car, would have traveled 4,500 feet. Didn't it? Traveled with about a third of that. It's 1,500 feet. The state presented evidence that Mr. Higgins, based on his statement that he gave to the police, was that he kept pumping the gas pedal, the accelerator, obviously trying to flee the scene. The car had already stalled. We don't know what that was. That's not a proper or a proper truth to put to the grand jury, because the grand jury didn't hear it. There's other explanations which were not asked of the trooper, like, well, if you're 1,500 feet away or 1,000 feet away and you're pumping the accelerator because the car's not operating, it could very well be that you're pumping the accelerator to get the car to start, to turn around, and to go back. If he was going to leave, he would have left. He had many opportunities to do so, and he didn't, Judge. Because one of the things that we've brought up under the case of State versus Tejon is the Tejon We're talking now about the bicyclist blood alcohol concentration and the fact that they obviously were intoxicated. So one of the bicyclists' blood alcohol concentration was a 0.129. Other bicyclists' blood alcohol concentration was a 0.134. We know that the drunk driving statute doesn't apply to bicycles because bicycles are powered by human power as opposed to combustion engines or electricity. The judge in State versus Radziwill said bicyclists are not subject to, or State versus Tejon, I apologize, Judge. The bicyclists are subject to the same rules and regulations that cars are. However, Judge, we know that that's not true because the definition of a bicycle is not the same as the definition of a motor vehicle. Judge said, though, and this, go back to the days of law school, you hardly use this word anymore, not the holding judge, it's dicta. Now, it's from a law division. I'm well aware, Judge, that that law division case is not binding here, but we have a split decision. The judge in Tejon said that although, or the duty imposed by the drunk driving statute is to refrain from operating a motor vehicle when intoxicated. However, the drunken operator of a bicycle may create situations endangering both himself and others on the road. He might, for example, swerve into traffic, cross the line into oncoming traffic, or fall into the path of traffic. Therefore, the operator of a bicycle is under an obligation to stay off the roads when intoxicated. We've got another case that came out, Judge, that holds the opposite, that you can't convict somebody under the drunken driving statute for riding a bicycle. And then there's a third case that comes out that sides with the second case I cited. What's the point of it, Judge? The point of it is there's a split decision here. We don't have an appellate division ruling on it, but we have other judges out there, Judge, recognizing the fact that if you're intoxicated, you shouldn't be riding your bicycle on the street, especially in that area because of the lack of lighting and such a small side on the road, which I'll call a shoulder, but it's hardly a shoulder. Judge, those are the facts that were presented to the grand jury with respect to the aggravated manslaughter. And I respectfully submit, Judge, that the evidence that the state did not present, for example, Trooper Pope's report that does not have any tire tracks in the grass, the fact that they don't know where the point of impact was, the fact that there's no mud or dirt or grass on the Jeep, the grand jury didn't hear that. It wasn't pointed out to the grand jury. The grand jury didn't hear Mr. Higgins's reasoning about why he went back to the right to justify his conduct, Judge. So I submit, Judge, that his conduct that night, while it possibly could have caused the death of others, was not probable that he would have. Judge, when we get then to leaving the scene of the accident under count 6 of the indictment, and excuse me, Judge. Judge, for leaving the scene of an accident, for leaving the scene of a fatal accident, the elements on the record, Judge. And these are the elements that the state is to provide to the grand jury by some elements, or some evidence, I should say. When we talk about leaving the scene of an accident, there's 4 elements which the statute refers to and references to New Jersey Statute 39:4-129, which I know Your Honor knows from municipal court practice, sitting on the benches. Leaving the scene of an accident is a traffic offense. The elements of that, Judge: 1, the driver of any vehicle; 2, knowingly involved in an accident; 3, resulting in injury or death to any person shall immediately stop the vehicle at the scene of the accident or as close thereto as possible, but shall then forthwith return to and in every event shall remain at the scene until fulfilling the requirements set forth in the statute under subsection C, which is to then further report the offense under 39:4-130, which is reporting the accident. The issue here, Judge, is one, what was his intent, Mr. Higgins' intent, after he struck the two bicyclists and then coasted for the 1,500 feet? The car was disabled. He stopped. He told, and this was not presented to the grand jury, Judge, a witness came up. He said that Mr. Higgins told the witness that he was the driver and that he had been drinking. That witness told him, I'm looking back to see, I see bicycles over there. At that point, Mr. Higgins did not know that he hit a person or two people. It's in his statement, Judge, to the police that when he first hit it, he did not know what he hit. One of the elements, and an extremely important element to leaving the scene of an accident, is knowingly leaving a scene where you've caused the death of somebody. Mr. Higgins realized after he had stopped that he had hit the two bicyclists. Now, he was 1,500 feet away. The statute doesn't talk about go out with a measuring stick or a wheel to find out how far away you were. It's just you have to stay at the scene. Well, we all know that Mr. Higgins stayed at the scene. There's body-worn camera videos of him performing standardized field sobriety tests at the crash location, Judge. But he was 1,500 feet away. What the state presented to the grand jury was that he intended to leave, and there's zero evidence of that. The witnesses didn't testify to the fact that he got back into the car to go, that he had called for a ride, that he was walking away. And in fact, judges, we know from the discovery in the case so far, because Mr. Higgins had told the troopers this at the scene, he had had surgery on his knee that week, and he had stitches in it. So to walk back another quarter of a mile or so to get back would have been very difficult for him. But he was back at the scene, Judge, did his best to perform the field sobriety test, but all of that information was not presented to the grand jury. The state's case lacks that element, that Mr. Higgins knew at the time that he hit a person or people, and he didn't know that, Judge. And because of that, the state's presentation on that count fails. Judge, as I said, this is a situation where the court needs to focus on the duty of the grand jury acting as a shield and as a sword. And those are put in place, Judge, the shield to protect those who are accused of crimes from overreaching by a prosecutor. Judge, I submit that the fact that the state did not present the elements completely means it did not present a prima facie case to the grand jury, which means the indictment is palpably defective and must be dismissed, including the counts, especially 3 and 4, Judge, and then 6 as well. Thank you.
Thank you, Mr. Best.
Thank you, Your Honor. I just want to, I beg Your Honor's indulgence. I'm pretty much going to read the law to Your Honor, because I think it's important to lay that foundation for what I want to go through. These motions to dismiss are fairly commonplace. The law is pretty settled on that, but I did want to lay that foundation. There are only limited circumstances where an indictment can be overturned. Those circumstances are when the indictment is manifestly deficient or palpably defective. When these circumstances are met, dismissal is only appropriate when the grounds are described in the clearest and plainest. Also, where the indictment alleges all the essential facts of the crime, the charge is sufficiently stated, and the indictment should not be dismissed unless its insufficiency is palpable. To uphold the indictment, the state must prove or present prima facie evidence to the grand jury. In reviewing the sufficiency of the evidence, every reasonable inference should be given to the state. The evidence presented does not need to be sufficient to sustain a conviction. What we just listened to is great evidence for a pettit jury to hear in closing argument, but it's not what is necessary for a grand jury. Grand jury is a process, is not adversarial. Evidence presented only needs to be sufficient to establish a crime has been committed, not establish guilt or innocent. Any challenge to the indictment must demonstrate the evidence is clearly lacking to support a charge. Because of the non-adversarial nature of the grand jury proceedings, incomplete or imprecise legal interpretations will not warrant dismissal. Indictment should not be dismissed if the grand jury heard at least some evidence as to each element of the offense charged in the indictment. Again, I do agree with counsel when he indicated that the state cannot present half-truths to the grand jury. That is not what happened here, though. The grand jury presentment was 2.5 hours long. It encompassed 2 witnesses and 14 exhibits. I believe there were 12 photos, half of which were the defendant's Jeep. The other half were John and Matthew's bicycles after the defendant had run over them. And the other 2 were the diagrams that were developed by the state police when they were doing their review of the crash scene. So the grand jurors had those documents to review when they were doing their deliberations. I'll start with the arguments that there wasn't enough evidence to support a finding of the extreme indifference to human life. What was presented to the grand jurors was that the defendant was intoxicated when he was operating his Jeep on the day in question. They heard testimony where the defendant admitted to this multiple times to multiple people. There was field sobriety tests where he failed them. Trooper Alenardo smelled alcohol on the defendant's breath, and they did a blood draw on the defendant, and it came back as a .087, which is above the legal limit. He was operating this in the vehicle while intoxicated, and he came up upon the Ford Focus, and he came up and the driver of this Ford Focus noticed the defendant because she said she was driving at 50 miles an hour. We know that because that's what she said in her statement. And the speed limit on that road, which was testified to, was 50 miles an hour. I believe that was all testified to at grand jury. The defendant would come up on her bumper and then pull back, and then go back on her bumper and then go back. It happened about 3 or 4 times, and then the defendant passed on the left. Again, there was no insinuation that the defendant wasn't allowed to do that. And then when he was doing that, the Bronco had seen the brothers and was moving over into the oncoming lane to give enough room to the brothers so they could safely pass, which they were allowed to do and which they should do. Oh, and by the way, it was dark out, which would mean that you have to be even more cautious on a road like this. So the defendant, wanting to pass both vehicles, goes into the in between both vehicles and wants to pass the Bronco, and that's when he strikes John and Matthew. And he keeps on going. There's testimony that the defendant indicates that he keeps on hitting the accelerator when his car stalls because the front driver's side or passenger side headlight is dislodged. It comes it dislodges from the wiring, and he can't get it started. He's trying to start it up again. and it coasts to a stop not 0.2 miles away, but a quarter mile away, over a quarter mile away, actually. And what does he do? He doesn't call 911. He doesn't talk to a 911 operator. He gets rid of the alcohol, the unopened alcohol and the open alcohol containers that are in his car, the evidence of his intoxication. And he calls, I believe, his parents or his wife. He makes phone calls and talks to other people. When he passed the Bronco, he got witnesses in the Bronco. He got witnesses in the Ford Focus that say he was speeding. The witnesses in the Bronco testified to their speed that they were going. They were all going the speed limit. The defendant was passing both of these vehicles. So anyone can infer that if someone's going 50, have to go faster to pass those individuals. So he was speeding at the time of this incident. And so when he was passing them, he was speeding. Now, there's much, I guess, that was written about the difference between the 3,000 feet between where the cruiser stopped when the troopers did their analysis of how far the defendant would have stopped if he didn't stop his vehicle where he did. When they did their initial analysis of the defendant's vehicle, they found that even though the car stalled, the car still could steer and the car could still brake. So he could have immediately stopped when he struck the brothers, but he chose not to. He continued to go as far as he could, and when he realized that he wasn't going to be able to get out of this situation, he pulled over. And it's a reasonable inference that he realized that he's intoxicated, he ran into somebody, and he has alcohol in his car. So he pulls over and gets rid of the evidence. There's enough there to show that he was exhibiting an extreme indifference to the value of human life. Now, I understand the facts of Radid's will are what they are, but the court said what the court said. And it said, a jury may infer that an individual who drives while intoxicated is consciously disregarding the risk of an accident and acting with an extreme indifference to human life. And he's talking about pedicures. So a grand jury can do the same thing. It went on and said that if someone leaves the scene of an accident, when someone flees the scene of a collision without stopping to determine whether he could render aid to any of the victims, provide additional support for the conclusion of the acted, let me rephrase that. When someone flees the scene of a collision without stopping to determine whether he could render the aid to the victims, that provides additional support for the conclusion that he acted with extreme indifference to the human life. That's kind of what we have here, Your Honor. The grand jurors can find that all of this supports a finding that the defendant acted with extreme indifference to the value of human life. Whether that's supported if this case goes before a petit jury, that's left for another day. But there was sufficient evidence presented to the grand jury. With regards to the diagram and the photo and what was or wasn't on the Jeep, there was testimony regarding the weather conditions at the time of the accident. I believe it was Trooper Alenardo that indicated it was dry at the time of this accident, so that there wouldn't be any tire marks on the ground, and there wouldn't be any grass on the vehicle. And if the grand jurors, if they had any questions regarding that, they had an opportunity to ask questions. And I know Your Honor read the grand jury transcripts. They did ask questions. They were not passive in this presentment. If they had questions regarding something, they did ask questions. Regarding the diagram is what the diagram is. If counsel has questions regarding that, they can ask on cross-examinations regarding that diagram. But it is a tool, it's not hard and fast. We have eyewitnesses that will testify to what they saw on the night in question. We have the driver of the Ford Focus that saw the defendant. We have the three witnesses in the Ford Bronco that saw what they saw. Now, with regards to the intoxication, and it was a puzzling argument when I read the defense's brief, in that defense indicated that the DWI statute should have been read, but then once you dive into the DWI statute, it doesn't apply because Matthew and John weren't driving a vehicle. They weren't driving a motorized bicycle. It was apparent through the photos that it wasn't a motorized bicycle. These was pedal bicycles. But then if you look, Your Honor looks at the brief, I believe it's their last paragraph, the last full paragraph of the brief. It says this is clearly not an argument that simply because the cyclists were intoxicated that somehow exonerates Mr. Higgins by way of an affirmative defense that the indictment should be dismissed with prejudice. Which everything before then indicates that. So I was kind of perplexed. So if that's true, then the arguments beforehand hold no water, in that it's not an issue, the intoxication. They did cite the law division case, and I provided you with the rebuttal to that is the other two law division cases that did an extensive analysis of the DWI statute and came to a different conclusion, in that there is no cycling while intoxicated statute. There's no way that anyone can be charged with that. So it's not relevant to the presentment in grand jury. With regards to leaving the scene of the accident, there was ample evidence that the defendant did leave the scene of the accident. Counsel kind of read the statute, but didn't read the entire statute with regards to that. I'll read what was read to the grand jurors. This comes from what's read to petit jurors in every case that's presented where leaving the scene of the accident is a charge before them. In order for the state to establish this element, the state must establish probable cause that the defendant did not fully fulfill any of the following obligations that New Jersey law places on a motorist who is involved in an accident. 1, immediately stop his or her vehicle at the scene of the accident. He did not do that. He stopped his vehicle over a quarter mile away, and he only did so because his vehicle wouldn't drive any further. Or immediately stop his or her vehicle as close to the scene of the accident as possible and return to the scene of the accident. Well, he never returned to the scene of the accident. He remained at his vehicle a quarter mile away. Whole purpose of the statute is to render aid to somebody that is injured in this accident or to remain on scene to help out anybody that needs help. And he did not do that. And 3, report all necessary information to appropriate authorities in a timely manner. He did not do any of that, Your Honor. A motorist who fails to fulfill any of these obligations leaves the scene of an accident under circumstances that it violate the provisions of NJSA 39:4-29. However, the state need not establish that the defendant know of his or her legal obligation to stop at or near the scene of the accident and report all necessary information so long as he or she knew that he or she was involved in an accident. So all he needed to know was he was involved in an accident. He doesn't need to know if he hit anybody or what he hit. I'm sorry. And he indicates he knew he had hit somebody. Your Honor, you saw the photo of the vehicle. It's impossible for someone to, with a straight face, do that much damage to a vehicle and not know you hit something. There is enough evidence here that was presented to the grand jury to sustain these charges. And dismissal of all these charges is unwarranted, and it's the state's request that Your Honor deny the request. Thank you.
Just very quickly. Now, Mr. Mastern said he mischaracterized the argument and the evidence. He said that Mr. Higgins didn't know that he was involved in an accident. How could he not have known that he was involved in an accident based on the damage of the car? It's not the argument at all. Mr. Higgins told the police that he knew that he was involved in an accident. At the beginning, he didn't know that he hit 2 people, and he didn't know that he caused the death of them. And that was after he was already stopped and at the scene, Judge. Again, I mean, the state's saying it's a quarter mile. I think it was a fifth of a mile. Regardless, Judge, he was still in the area.
So he's admitting that he knew that he was in an accident, so he had to stay on scene, and he did not do that.
Judge, the witnesses said he was freaking out because he was involved in an accident. If Mr. Mastern thinks that Mr. Higgins was going to leave, then Mr. Higgins would have called somebody and left. Mr. Higgins would have hobbled away as best as he could on his knee. The bottom line is the state is trying to divert the court's attention and try to focus on the fact that he was 1,500 feet away. Doesn't matter, Judge. It's irrelevant. What's relevant is, did he know that he hit people and caused a fatality? And that was never presented to the grand jury.
Thank you, Counsel.
Your Honor, he had to stay with the car. That was his only choice. Stay with the car and try and talk his way out of the situation. His house was not too far away from the situation. If he went to his house, they were going to find him no matter what. He was the only one that was going to be at the house. He knew that. They were going to trace everything back to him. So he might as well stay with the car and try and get rid of the evidence, call whoever it is that he called, and try and get some help on that end. Thank you, Your Honor.
Thank you, Counsel. I appreciate it. This is a motion to dismiss counsel the indictment filed by the defense. The court has had an opportunity to review the grand jury transcript, the submissions made by both counsel, as well as the arguments made here today on the record. And as counsel pointed out, the controlling case regarding grand jury indictment and whether or not it's appropriate to dismiss an indictment is State v. Hogan 144 NJ 260. It's court often refers to Hogan because the court is often faced with motions to dismiss indictments. The key language in Hogan specifically indicates prosecutors are obligated to inform a grand jury on any evidence that is clearly exculpatory or that directly negates the guilt of the accused. Further, Hogan also goes on to indicate, and it's set in the brief that's been filed. Court grand jury cannot be denied access to evidence that's credible material and so clearly exculpatory as to induce a rational grand juror to conclude the state has not made out a prima facie case against the accused. If evidence of that character is withheld from the grand jury, the prosecutor, in essence, presents a distorted version of the facts and interferes with the grand jury's decision-making function. The grand jury must determine whether the state has established a prima facie case that the crime has been committed and the accused has committed. The grand jury not only must bring the guilty to trial, must also protect innocent from unfounded prosecution. Indictment handed down by a grand jury should be disturbed only when the indictment manifestly deficient or palpably defective. The court starts with that as a jump-off point because the court would have to, the defense would have to establish there's a manifest deficiency, palpable, defective indictment that's been presented to this grand jury. As the court indicated, this was a very thorough grand jury presentment. I did read Mr. Mester testified that it was over 2 hours. Present 2 witnesses, but the grand jurors did ask questions. So the grand jurors did their due diligence. They did their duty as grand jurors in this case. So when I look at everything in its totality, and I consider first the state's defensive motion dismissed counts 3 and 4 of the indictment, which allege aggravated manslaughter. The argument primarily is the conduct that was exhibited by the defendant in this case was merely reckless and did not rise to the level of manifesting an extreme indifference to the value of human life. And the distinction is recklessness would create possibility of death, and manifesting an extreme indifference to the value of human life would present a probability. The state is directed to court to the case of State versus Radiswell. Let's talk about the fact that a defendant consuming alcohol to the point of intoxication, at least for grand jury purposes, can be held to the standard of a manifesting an extreme indifference to human life. In this particular case, not only do we have consumption of alcohol, we have witness testimony, at least what should I say, statements made by witnesses to the state police we investigated, who then provided that witness testimony to the grand jury that Mr. Higgins, the defendant, was operating his vehicle at what appeared to have been a high rate of speed, given the fact that the vehicle in front of him was doing 50, and he was coming up on the bumper multiple times. He then passed that vehicle on the left, as pointed out by defense counsel. There was no charge for improper passing of any rate, but apparently it's broken down the line, so he made pass. The issue then becomes, once he passes on the left and the vehicle in front of the first vehicle moves into the left lane to avoid the bicyclist, Mr. Higgins then pulls back into the right lane, at which time he strikes the bicyclist, which results in death. When you look at the combination of fact, alcohol, manner in which he's properly doing it, one finds that there's enough patient evidence in this case to establish the charge of aggravated manslaughter on count stated 4. Grand jury present clean in that regard. The evidence is enough to overcome a prima facie showing. As indicated by Mr. Mester, obviously, in case before trial of fact, the state and defense can place their positions on the record. Many of the arguments made by Mr. Portella may have bearing on a trial of fact. At this point, the burden is not proof beyond a reasonable doubt. It would have to be established before the trial of fact. It's only a prima facie showing that the crime has been committed and Mr. crime. So, with regard to counts 3 and 4, the motion to dismiss is denied. With regard to count 6, defendant argues count 6 of the indictment, which is leading the scene of a fatal motor vehicle crash, would also be dismissed as he claims the defendant did not actively leave the scene. There is some contradiction and controversy with regard to exactly what happened here at the scene. Obviously, Mr. Higgins' vehicle comes to rest approximately 1,500 feet from the scene itself. Well, state and the defense have argued specifically 39-4-129 and its requirements. There's also the grand jury charge, which is presented, the jury charge, which should be presented to the head jury, which was also advised to the grand jury. They heard the elements. Based on their hearing the elements, they made a determination that there was in fact a prima facie showing that Mr. Higgins, defendant, did in fact leave scene the crash. Once again, not proof beyond a reasonable doubt, but a prima facie showing. The question is, what was in the mind of the defendant at that time? It's third, obviously, that at this point, unknown. He has given statements to the police, questions, the witnesses at the scene, but the evidence not to bring the vehicle to a stop immediately, that it coasted for a period of time. And I think when the trooper did the, I'll call reenactment with the troop vehicle, there was testimony that the troop vehicle, while it lost control due to the stall out, was able to coast for about 4,500 feet. But he indicated that there was, the vehicle could have, brakes could have been applied and the vehicle could have come to a stop in less than 4,500 feet had they chosen to do that. The idea was to see how far it would travel in neutral after coming to a stop after stopping 50 miles per hour. So under the circumstances, as questions and the inquiries during presentment, not inquiring, we found there was enough to establish a crime case showing, and this court is not going to be disturbed by the grand jury's sound decision in this case. And for that reason, denying the state's or the defense's motion to dismiss fix of the indictment. There was also argument made in one of the submissions regarding the state's failure to discuss contributory negligence with the jury. Obviously, it's not argued here in court today, but the court finds that obviously contributory negligence is not part of criminal realization. Civil nature, the court once again finds that there's no credence in the argument that there will be contributory negligence on the behalf of the cyclist. In this case, there's no basis in the law for that argument, but it does consider it. So I am upholding the indictment each and every count. And I believe there's any basis. That's the matter of proceeding that. Thank you.
Thank you, Judge.
No, Your Honor, thank you.
They,
I think we're on FCDC. Should we go DC, Judge?
bring it to this discretionary conference, and we'll do that on the list of stuff. Intent work for all counsel.
Your Honor, just before we get to the scheduling thing, for the discovery issue for the private lab, what was your finding on that?
At this point, I deny that. I don't think so.
Okay, so regarding, so if it's the state's fine with FCDC, we're at FCDC today.
Yes, we're going to move to a discretionary conference.
Okay, then state's ready for PTC. If it's DC, I would ask for excludable time.
Are you ready for PTC?
We don't have all the discovery.
Yeah, we will.
That's-
We will be soon, hopefully.
But yeah,
I think that's good, Judge.
I understand the state has the issue with regard to excludable time, Judge, but this is, again, a lot of what has been requested was requested literally within 10 days of these charges. This discovery was requested from the very beginning as to the blood. The other stuff that we have asked for is not something that's outside the ordinary. So I don't believe it's something that should be counted against the defendant. So I don't know how we go to pre-trial if we don't have discovery.
And defense counsel very early on indicated they wanted access to these vehicles, and we have given access to the vehicles, but we haven't heard anything regarding their experts wanting to look at these vehicles as well. So it kind of goes both ways. The state is ready.
The civil case.
Thanks, Judge. I've actually emailed and called Mr. Mestern about it. We were supposed to do this back when Mr. Flynn had the case, but then it switched. Then I followed up with Mr. Mestern. I'll just follow up with him, Judge. That's fine. I mean, we're still awaiting discovery from the state anyway.
And there's also an issue, Judge, with the civil matter we did not want to, until the civil matter, which just recently resolved itself, not want to do anything that would have impacted that until civil counsel had an opportunity to, since they technically own the motor vehicle now, the insurance company owns the vehicle.
Understood. So we'll bring it back on the discretionary conference 610 with all the discovery complete. That documentation should be provided with regard to 5/16/19. There's no reason why it shouldn't. It's all information that should be readily available. Obviously, the independent audit, if for some reason it's not complete between now and then, it's advice board and advice council. Yeah.
With regard to 19, I'm hopeful that it'll be done by the end of the week. If not, I'm out next week, but when I get back, hopefully it'll be in. Yeah.
Sure.
And with regards to the application for excludable time.
Okay.
I don't think we should fall on defendant. This is discovery. We requested. Your Honor says we're entitled to that discovery. Nothing else held it up. Our motion for the discovery would have brought us to the same point where we are right now. I did have one other thing to place on the record, Your Honor, with direct discovery when you get a chance.
Exactly. Can I read something? Sure. Yeah, that's on 2 months. Yeah. See, here's my dilemma, gentlemen. I'd like to, under the circumstances, we'd be bringing this case back in a lot shorter turnaround, 2 months, which is June 10th. Obviously, given the fact that there are some discovery issues that are outstanding, under the circumstance, I think excludable time would be appropriate, but I don't think the entire period would be appropriate. So, yes, what my thought process is that to give half of it as excludable time, and then the other half would not be excludable. We can then come back on June 10th and see where we stand and move it to PTC on that date. So what I'll do is between now and what I would normally bring it back in about a month, I'll call the standard time. Then any time from, I guess, let's say from May 15th through June 10th will be excluded.
That's a fair compromise, Your Honor. Thank you. So the next date will be PTC?
No,
DC. Okay.
DC consists on June 10th with excludable time between 5:15, 6:10.
Thank you.
Judge, I just had two other things I wanted to place on the record that I will put in writing as well. Well, I think I put the one on writing. Any communication that the state had between themselves and the lab regarding 5/16/19. I need that. And with regard to
You're referring to correspondence?
correspondence, emails, whatever they had. And the other thing would be, Judge, with regard to the black box, second testing with the chip, if there was any written correspondence from whomever performed it to the state, I'd like that. I also would like, if it was a different person or different parties who performed the second testing with the chip, their CV, their background as to utilizing that, Judge. That's all.
And I'll just ask Mr. Kleinberg that you confirm that in writing to the state.
Oh, I will. I have a formal request for it. I was waiting to see if there actually was a full other report. It seems there isn't one.
And I think we discussed that.
Right.
The state is relying on its accident reconstruction report as
That's
it
fine.
stands. The infotainment system information was provided, correct, Mr. Mester?
Yes. Yep.
So obviously, if the state,
If there's an additional report, I'll send it over and
right,
whatever.
or the state can have its reconstructionist provide just a short letter to the defense saying we're solely relying on particulars that were set forth in our original accident reconstruction.
Correct.
And if there is a change to that report, of course, that
Obviously,
allows
it would
to.
be them.
Yes.
If there's a new report, it'll be sent as well.
Understood. Right. Anything further?
No, Judge.
No, Judge.
The only thing is we can't get our report done until we know the state is at their last report. So when the state says we're done, this is our final report, we can then get our report together. That's all I'm waiting for, is the state to say, this is it, we're done, this is our evidence. Each time we've been here, they said this is it. So the state says today, the evidence they have, other than what these 3 items I asked for, is it. We can move forward with our expert. I don't want to end up having to get 2 expert reports in the end. That's all.
I'm making phone calls when we leave here today, Your Honor.
Thank you, Mr. Mester. Thank you, counsel.
Thank you, Judge.
Thanks, Judge.
Thank you, Your Honor.
Oh, I'm sorry. We need you time.
Time.
What?
What time,
Time
Judge?
for the hearing.
1:30.
Oh, 1:30, yes.
Is that on the subpoena?
1:30 or 6:10.
I'm here all day, so whatever you.
That works for me, Judge. I'll get a copy. I'll scan it. I'll get a copy of the subpoena. I'll scan it to you.
Why don't you get a copy of that? Scan it.
Okay, let's see there.
Thank you.
All right. We shall recap what we heard. We also got some pictures we can show. So let me pull it. They had a motion to hold on. They had a couple motions. Motion to compel the state to turn over blood evidence. Judge denied that. Motion to request additional plea offers made. So apparently the state calls and they had a written deal of 20 years, but then they said, no, that's an error. So the 35 years stands. Then he cites other cases where drivers had 0.22 blood alcohol content and he was smoking and he hit a cyclist with a 3-year-old in the back seat and he only got 7 years in front of this judge. The judge did the same. This was the same judge. Then there was another one. The person only got a year. His blood alcohol content was higher than Higgins. That was only 1 year. And they're saying, the defense is saying, just because there's cameras here in the courtroom, you know, this is a high profile case. So that's why they want 35 years. So they're saying they're asking 5 times the amount when a similar situation where a school teacher is killed and there's a 3-year-old in the back seat. So, did the judge dismiss that as well? So here's what I want to pull up. Let me pull this up. Because all right, I want to pull this one up because this is, while they were going, this was really helpful because while the defense was going through their motion to dismiss this altogether, they were showing what happened, which I appreciated this. I thought this was really good. All right, so because I'm trying to figure out how did this happen, right? And we saw it's pretty rural, right? It is pretty rural. All right, so here's the deal. All right, and I didn't get this. So he's saying he did not actually go onto the shoulder, and it's a small shoulder. It's only like 3 feet wide. I thought it might have been a bigger shoulder. It is a small shoulder, and there are fields. I don't know if they're cornfields or not because it's Jersey, but it's some kind of field. So they're saying they can, okay, so he was driving home from Taco Bell at 8:30. He was on the right side, right? There's a Ford Focus and a Bronco that are going about 50 miles an hour in front of him. So he comes up and he tries to pass and he goes on the left, right? So that's a dashed yellow line, as you can see, right? So he goes to the left. The Bronco pulls out in front of him. So Higgins goes back to the right. And then that's where the brothers were. The brothers were in the lane. Higgins doesn't see them. The Jeep is disabled. He hits the brothers. A wire is pulled from the headlight, and it stalls out 0.2 miles or 1,500 feet away. So that makes a whole heck of a lot of difference because I thought he tried to pass on the right. So he didn't. I'm not saying this guy's innocent. I'm not saying that at all. I'm just saying I thought he was road raging and he pulls over he tries to pass him on the right. So he tries to pass legally. The Bronco pulls out in front of him. Like, why would the Bronco do that? And then so Higgins moves back, and then that's when he hits the brothers. Right? So that eventually was dismissed as well, or denied, I should say. Judge did not allow for that either. So I thought that was pretty interesting. Let me play one more thing. We got Lori coming up in like seconds, but I do want to play this. This will kind of show you. This is only 2 minutes. All right, so check this out. This will show you how rural it really is.
On the man's driving record, Claudia, what were you able to learn?
Right, Trace. Well, we have
on the man's driving record, Claudia, what were you able to learn?
Right, Trace. Well, we obtained the New Jersey driver history for Sean Higgins, and we found that Higgins had previously been stopped by police for unsafe driving and other violations and accidents.
Mr. Higgins, you're here today for a pretrial detention hearing.
Sean Higgins appeared at today's court hearing via remote feed from Salem County Jail. He was supposed to have his first hearing since being arrested 1 week ago.
This matter is going to be adjourned until September the 13th. The state and defense would both like to supply the court with additional documentation.
It's unclear what that documentation is. We reached out to the prosecutor in the case, but have not yet heard back. Higgins' lawyers issued a statement that says in part, "This is a tragedy involving a great deal of emotion and impacting many individuals. It is too early in the stages of the legal process to make any out-of-court statements." According to the criminal complaint, Higgins operated his vehicle in a reckless manner and unlawfully passed a vehicle on the right side, at which point he struck Johnny and Matt Gaudreau, who were riding their bikes on the narrow shoulder of the road.
So I just wanted to pause it there. So there's really no, like bikes, even a bike can't even drive on or ride on that shoulder. I mean, that's like, you have to kind of ride in the road. Right? You can't really, there's nowhere to ride a bike. So, and again, I want to know, so they were driving, or the brothers were riding their bikes home? They were drinking, obviously. Like, where were they going to? Like, back to somebody's house, I guess? Somebody lived there? All right, let's see what else.
Shoulder of the road. The brothers were pronounced dead at the scene, the complaint said. Johnny was a 7-time NHL All-Star with the Columbus Blue Jackets. His younger brother, Matt, played professionally as well before returning to their South Jersey hometown to coach at a local ice arena. According to the affidavit of probable cause, Higgins remained on scene after the accident and told police he had had 5 to 6 beers before the accident. Higgins also told police that he was consuming alcoholic beverages prior to and while operating his vehicle. Through an open records request to New Jersey's Motor Vehicle Commission, the NBC 10 investigators obtained Higgins' state driver history record. Some of the incidents and information were redacted, but we know that Higgins was involved in 2 vehicle accidents, one in 2016 and the other in 2021. He was also cited between 2003 and 2014 for improper operation in a highway with marked lanes, improper display of plates, speeding, and unsafe operation of a motor vehicle. The State of New Jersey Motor Vehicle Commission has Higgins listed in good standing at the time of last week's fatal accident. During today's court appearance, Higgins only spoke at the conclusion of the proceeding.
We also found 2 violations in North Carolina, a driving while intoxicated in 2005 and a speeding ticket in 2001. Both of those were dismissed. And according to court records, the DWI was dismissed because the officer did not show up for the court date. Now, I should mention the New Jersey affidavit states that Higginson's blood was drawn the evening of the fatal accident. I asked the prosecutor what his blood alcohol content was at the time of the crash, but we have not yet heard back. Those results may be part of what is introduced before the rescheduled pre-trial hearing next Friday, the 13th.
All right, so the other thing I want to read before we jump off, because we got Lori Daybell coming up, is that, okay. So the driver of the Ford Focus, right? So Higgins is coming up on them going 50 miles an hour. So there's the Ford Focus says she was traveling behind a Bronco when she noticed another vehicle coming up behind her at a high rate of speed. The driver says she noticed the SUV speeding up, slowing down, then speeding up again. That happened 3 or 4 times while being tailgated. She was so concerned about this, she thought about pulling over. While this was happening, authorities say the vehicle in front of her, the Bronco, started to apply its brakes and move over. As this happened, she spotted the Gaudreau brothers not in the lane of travel, and she was confident they were biking on the fog line. As the driver moved over, she said Higgins passed on the left at a high rate of speed. The defendant then swerved in front of her after passing her and then saw the defendant hit the brothers. While speaking with troopers, Higgins allegedly stated that he was impatient and decided to pass vehicles. He also allegedly said he thought the driver of the Bronco was trying to prevent him from passing. He admitted that he didn't see the victims before he struck them. Authorities said the brothers were unconscious but breathing when one 911 call reported the tragedy. Autopsy report states they died from blunt force traumas as a result of being struck. Now here's the other thing. Higgins, he was a major. It says the father of 2 had served in the 44th Infantry Brigade combat team in Kosovo and was promoted to major during a state leadership visit to the former Yugoslavian Republic in 2019 when he credited his family for their support during his military career. He also served as the Regional Command East Civil Military Cooperation Chief during that tour. It's unclear if he's still currently enlisted in the U.S. Army. The major is a field artillery officer assigned to the New Jersey Army National Guard Joint Force Headquarters and works part-time as a traditional drill status guardsman. So, all right, so there you guys go. Thank you for joining us. I'm going to bounce off of here. We got to get ready for Lori. We're going to do a little pre-trial prep with Lori. We're going to show her interviews, her interviews after Charles got shot. So I will leave you with thank you for joining us. Thank you, Aaron, for doing all the work on the back end. Thank you to our mods. Thank you to OnlyFan for finding some information. Trial Junkies United, you sent us that some information as well. Thank you, guys, for joining us. We have a redirect set up for Lori Daybell. She starts around 1:15 our time, I think. Yeah, 1:15. But before that, we're going to play her interview that they were talking about. Remember, they were showing like a second clip, 10 seconds, 10 seconds, 10 seconds. We're going to show the entire interview so that you guys can see the entire interview. So with that, thank you for joining us. Redirect is set. I leave you with Super Bowl, chilling, and we'll see you in 10 minutes for a Lori Daybell police interview after Charles got shot. Bye. Yeah.